Okay, great. Thank you. Thank you for the kind introduction earlier, John. I'm very excited to be here. When John asked me to come, I jumped at the opportunity because the fact that you guys have a class about video games and that I get to come back to a law school, which was an experience that was probably 3 of the greatest years of my life. I loved law school, so it's a great honor to be here. And I've never been to Vancouver before, so it was a chance to see your lovely city. Before I get into what I wanted to talk about, I wanted to say a word about Sony versus Universal, which is a case that comes up a lot in my practice. I don't know whether you all are familiar with that case or not. It was the 1984 Supreme Court case that stands for the proposition that the manufacturer of a device that is capable of substantial non-infringing uses should not be held liable for infringement committed by the users of that device. And that comes up for me a lot in my practice because of who I work with. I work with technology companies in Silicon Valley, primarily, who come up with all sorts of technologies that can be used in various ways, some of them to commit copyright infringement. So for example, I worked on the defense of Napster early in my career. I worked on the defense of a company called Sonic Blue that made a device called the Replay TV 4000. I don't know whether anybody is familiar with that device. It was a device like a TiVo that had a feature on it called auto skip that allowed you to skip through the commercials. And so, not surprisingly, they got sued by pretty much the entire entertainment industry, and we represented them in that case, and we relied heavily on Sony in that. I also wrote an amicus brief to the Supreme Court in the Grokster decision, which is the case that announced a new theory of liability, a new theory of secondary liability called inducement, which is the notion that if you distribute a device with the object of promoting infringement, that you can be held liable under secondary theory of liability. So, and I'm currently representing CBS Interactive in a copyright infringement suit that attacks they have a site that they run called download.com where you can get virtually any kind of software. And they've been sued by a number of recording artists under the theory that because they distribute P2P software, which is then in turn used by people who use the software, like the BitTorrent protocol, for example, that CBS Interactive ought to be held liable as a secondary infringer. So Sony versus Universal is something that I talk about and rely on all of the time. So it's a very important case, and I encourage you to read it and think highly of it because it's a great doctrine. So let me just scroll down here. Okay, so there are a few things that I want to cover today. I want to talk about who I am, why I'm here, and in particular how I got to be in a position to build a practice around video games, which is a dream from my perspective. I want to talk about the kinds of IP disputes that I typically see in my practice, which generally revolve around copyright, trademark, and right of publicity. I don't see too much in the way of patent, and I don't do patent litigation, so I'm not going to talk about that at all. I'm going to spend most of my time talking about the cases in this area. There are a lot of really interesting ones. I've been involved in some of them. And where I can offer it, I'm going to give you the backstory because a lot of it is very interesting. In particular with cases like EA versus Zynga, some of these cases are driven by emotion of the developers. And so there's a lot of interesting backstory there because, as we'll talk about, no one is really willing, with the exception of Tetris, no one is really willing to push the envelope and let a court decide where the line falls between what's protectable and what's not. I mean, think about the ramifications for the video game industry if a court were to decide and to get it wrong. Or if a court were to decide for example, in the life simulation genre, that it was an infringement. I mean, what would that mean for the game industry? So that's definitely something that's worth thinking about. And then finally, if we have time, I'm going to walk you through how I go about analyzing IP claims in this area from a practical perspective. So I told John that I wanted to ask you this before I start. I'm just curious, why is it that you all are taking this class?
I'm assuming a lot of us really love video games. Maybe a few of us kind of like the law, too.
Yeah, yeah. Are there those of you that are hoping to build a practice around something with video games, either litigation or transactional? Anybody? Yeah?
I think it'd be interesting to do. It's harder for us, I think, at this point to dictate exactly where we're going to end up with our practices.
Yeah, oh, absolutely, absolutely. I certainly didn't have a clue when I was in law school what I would do, much less think that I would do anything with video games. But did you have something you wanted to say?
Oh, no, just, yeah,
No.
I would love to build a practice in this. It's so interesting.
Yeah, it's fascinating. It's really fascinating. When I was in law school, I did not know what I wanted to do. I knew that I wanted to be a litigator. That's just my personality. I'm competitive. I like to win. I like the strategy. It's kind of like, litigation is kind of like chess. You've always got to be thinking 10 moves ahead, which is why Civilization Revolution is my favorite game of all time, so I'm completely addicted to it. So I knew that. I didn't know what I wanted to do substantively. I did know that I loved intellectual property, so I took all the courses. I took copyright, I took trademark, I even took patent, which confirmed that I wasn't interested in that. But I knew that I liked that, and so when I started out with my practice, I focused a lot on copyright. I graduated from UCLA Law School in 1997, and there was a lot of interesting things going on in copyright law at the time. You know, the internet, people were really starting to get into email and the internet. It was before the DMCA. There was just a lot of interesting stuff, so I was really drawn to copyright. But it wasn't until I'd been practicing probably 12 years that I started working with video game companies, Capcom in particular, and Sega and a bunch of others. And then I worked on the Capcom versus MKR case, which I think you've talked about in class. And it combined my love of deep copyright analysis with video games. And I had to play the game. And I got paid to play the game and to watch the movie and to analyze it. And I just thought, why am I not doing more of this? So I started doing more and more and more of it. And the more I did, the more opportunities that arose. And so that's how I ended up where I am. And I'm also a huge, huge, huge gamer, which you're probably getting the sense of. I have been my whole life. I grew up with Atari, and when I was a first-year associate and I got my, they gave us a spot bonus one day. Just unexpectedly, they came around and handed all of the associates a check. Can you imagine? So I said, I'm going to go buy a PlayStation. So I went out and I bought a PlayStation, and since then, of course, I have PS2, PS3, I have an Xbox, I have a Wii. And as John knows, my first Xbox I burned out. I experienced the red ring of death playing Civilization, and I was devastated. So I am a true gamer, and I love everything about my practice that relates to video games. So there are two things that I do in my practice. Although I consider myself a litigator and I'm called a litigator, what I really view my job as is dispute resolution. When there's a dispute, I try and make it go away, or I try and prevent it from happening. So what I do a lot of my practice is advise clients during the game development process, and I encourage them to show me a prototype or a beta version or something, please, before you put it on the market, let me see it, let me play it, let me analyze it, let me make sure it doesn't run afoul of somebody else's copyright. And so there have been many times that I've had the opportunity to recommend tweaks to a game. Please change these graphics, or move this feature down here, or change the color scheme, or don't use that icon. I think I left my iPad. I left my iPad over here. But a lot of the times, I have a ton of games on here because I actually do really play them for work all the time, and my son can't believe that I have so many games on my iPad. But you see sometimes that, and this is a case that I'm going to talk about. Do you guys know Triple Town and Yeti Town? Anyone? Okay, we're going to talk about that. The icons look very, very similar. I'm like, guys, come on, come up with a better icon, come up with a better name. So I do a lot of the counseling during the game development process, and I also do dispute resolution when it does happen. Typically on the defense side, but sometimes I'm also on the plaintiff side. And what's funny about that is that I often have clients who initially come to me because they've been accused of copying somebody else's game. And I talk to them about that. Okay, you know what? I think I can defend this. I think we can win, but If you get sued, you might get sued in another country because a lot of times these developers are in different countries. And so why don't we just tweak a few of these things and we'll try and make this thing go away? Because if you can make changes to the game such that if you were to get sued, the plaintiff's not going to get an injunction, there's not a lot of leverage, you probably won't get sued. So let's just make some changes and then it'll all be fine. Now these same clients, once they achieve some measure of success, suddenly think, well, now they're copying me. And they want to go after all these other companies. I'm like, wait a minute. You're pointing to a feature in their game that you copied from someone else. Do you see the problem here? Okay, okay. But this is very, very, very common. So we're going to talk about everybody is copying everybody else in the game space. Which brings me to the perspective of, from the gamer's perspective, what does this mean? Well, from a gamer's perspective, I love that everybody is copying everybody else because there's more games to play. And as my 7-year-old pointed out, sometimes the copycats are better than the original. I'm going to use the example of Triple Town and Yeti Town that I mentioned earlier. Triple Town came out first, and Yeti Town was developed by a company that had been hired by the makers of Triple Town to create an iOS version of the game. And things kind of went south, and they ended up coming up with a knockoff of the game. And one day my son started playing Triple Town on my iPad, and he got to the point in the game when he would have had to pay money to go beyond a certain point. And I said, no, 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 just turn on Yeti Town, it's the same thing. So he's like, what? What is that? I said, it's the icon right next to it. It's the picture of the Yeti instead of the picture of the bear. So he starts playing Yeti Town, and he says, well, this is a better game. I said, really? It's a ripoff. And he said, well, that's why it's a better game, because they created it second. Interesting observation from a 7-year-old. So from the litigator's perspective, what do I think about all this copying? Well, it depends on who I represent. So that's all I have to say about that. Excuse me 1 second, I need to get a tissue. I have some here.
Oh, sorry.
Yeah, I have a little bit of a cold. Okay. Okay, so I know that you guys have spent some time talking about copyright. It's the issue that I see most in the video game, in this area of my practice. But I just want to hit on these points very, very briefly because they're going to come up when we talk about the cases. So as you know, copyright is a statutory creature, and it is governed exclusively by federal law. And what it copies is the expression of ideas, not the ideas themselves. So when you're on the defense side, of course, you want to argue that everything that was taken was an idea, or a concept, or something driven by the idea. So in the video game concept, there is no protection for things like, for general concepts, plots, themes and genres, scène affaire, ideas merged with expression and content not original to the author. And we're going to talk more about that. And
can you explain scène affaire just a little bit?
Yes, scène affaire is something that is part and parcel of a particular genre. Like in a Western, you might have a shootout in the main street. Or in the zombie genre, you might have a town that is quarantined, and the only means of escape from the town is a helicopter, right? You can't drive a car. So these are kinds of things that you would expect to see in a particular genre. So when you think about what's protectable in a game, it's important to understand the genre that you're in and identify what are the common elements that you expect to see in every game within that genre. And we're going to talk about that when we get to the practical analysis piece of how you go through the steps that I go through in trying to identify when somebody has crossed the line. So let's talk a little bit more about copyright.
How do you distinguish between plot and storyline? How do you distinguish between plot and storyline?
Plot I would describe as something that is very general and high level. I could probably give it to you as an elevator speech. When we're riding up the elevator, I could tell you, well, I'm going to create a story about two people that meet and fall in love, and they move to Paris, and they have a baby, and something along those lines. Storyline, in terms of what's a protectable storyline, that's when you really start to fill in the details of the story, the dialogue, the interaction between characters, between particular characters, not just stock characters.
So if you got down to something like a scene-by-scene analysis of a game or a movie, that's particular enough to constitute protectable storyline versus plot?
Yes, I would argue that. A particular sequence of events, yes, where story follows along, yes, yes. Let me give you an example on that. In the Capcom case, the court noted that although there were similarities in the high-level plot of it's a zombie outbreak, and they're barricaded in a mall, and they got there by a helicopter, the court noted that the first couple of scenes, there were actually some differences because in the movie, they started off in a news studio, and then they got to the mall. Whereas in the game, they pretty much started off riding the helicopter and landing on the top of the mall. And then from there, the movie and the game went in wildly different directions. I mean, part of that was that it's a game and it's interactive, and so the player decides where it's going to go, and it changes the possible endings and all of that. But it didn't have the same sequence of events beyond actually once they got to the mall, so there was a huge difference there. Okay, so let's talk for a minute about the elements of a claim for copyright infringement. There are two. The first is that the plaintiff has to have a registered work that they own. And the second is that they have to prove that the defendant copied protectable elements of their work. And I know that this is a class about video games, and so the second element is more important, but please, I just want to emphasize something about the first element. There's gold in them there hills, okay? Ownership is a very complicated issue, very complicated. I often say, and I'm usually right, that there is something about ownership that the plaintiff does not want me to know. So if you decide to become a litigator and you litigate copyright cases, get out your shovel and dig. Because just because the plaintiff has a copyright registration in their name does not mean they own the work. There could be something there.
Do you need registration for standing, or I thought registration was, beneficial from an evidentiary point of view. What do you do without it?
So, well, in the United States, you have to have a registration, and in some jurisdictions, it's enough to have it be pending. But you do have to have a registration. But what I'm talking about is maybe the person. There could be an issue with a work for hire agreement or an assignment. I see that a lot.
And in Canada, you don't need to have a registration, but the basic issue around digging into copyright origination is equally valid, beyond question.
Yeah, and it's actually in the video game context, the big issue here, and this is my point here, is what was copied original to the claimant. This is another way of talking about the ownership issue. Do you own it, Zynga? You think? Does Zynga create their own works? Just giving you an example. We're going to talk about Zynga. So the second element, copying of protectable elements, that's important because if what you copy is not protected by copyright, you're probably home free. I mean, there could be other issues. There could be trademark or right of publicity claims. But in order to face liability for copyright infringement, you have to take something that's covered by copyright. And so in the Capcom case, we argued that all of the similarities were based on similarities in the high-level idea. Nothing was protected by copyright. And so we said it doesn't matter if people think we ripped it off, because they really relied on that heavily in that case. Well, everybody in the press says that the game is a total ripoff of the movie. And they approached us about a license, and we turned them down, and then they went ahead and ripped us off. And the developer showed up at the launch wearing a Dawn of the Dead t-shirt. These guys ripped us off. Well, you know what? So what? Doesn't matter, because if what you take isn't protectable, that's not copyright infringement. So the two issues that I see most often in these disputes, like I mentioned, is what was copied original to the claimant, or did they copy it from someone else? That's when you have to go back and you have to look what else is in the genre, what else is out there. Who did the plaintiff copy from? Who were they inspired by? And then you look at what was copied part and parcel of the genre. Maybe it's just something that everybody does. It's a scene that must be done, a scène affaire. So we're going to talk about some of the, there are a lot more cases that I could talk about, but these are some of the more interesting ones that we'll go through, and I have slides for each of them. I would encourage you to read the ones that have actually resulted in a written opinion if you haven't already. The Atari versus North American case, it's an older case, but it's a good one because it talks about, it has a good discussion of the difference between what's protectable in copyright and what's not. And it has an interesting observation in there that, I say this a lot in the cases, if a game is based on the real world, the copyright is much more likely to be thin than if something is totally fanciful, like Pac-Man or Tetris, where there's not some equivalent in the real world that you can point to and say, well, this element is obviously drawn from the real world. You have to have a desk that has 4 legs, and you have to have a chair that goes in front of it, and all that kind of stuff. It's totally fanciful. So historically, courts seem to have given more copyright protection to games that are just completely fanciful, like Pac-Man.
So just one footnote. If indeed gaming is moving more into the real world, it will be harder on that theory to protect games.
Right, right, right. And a lot of people were very, go ahead. Go ahead.
Well, I was just wondering, if you have to register it, it seems like there would be protectable elements coming up along the development process. Do they register it as soon as it's done? Because timing probably is something quite important to them. So do they wait all the way to the end of the project and then register that, or do they register each?
So rights arise from creation and fixation. It's that you can't enforce them, at least in the US, until you register. And the law is complicated on the issue of when you register, what does it go back and how many versions does it protect, but there is precedent suggesting that it will go back and protect all the pieces along the way. But so copyright is different from trademark in the sense that when your protectable rights are created, in trademark, your rights, a registration, you can apply to register something before you're actually using it, but you don't actually have any rights until you've used the mark in commerce. Okay, so in addition to Atari, Capcom did result in an opinion, and ignore this one because that's a sideshow dispute. Tetris, I highly encourage you to read. That's a fascinating opinion. And the Spry Fox versus Lola Apps, that was a motion to dismiss ruling, and then the case subsequently settled. But it is a nice opinion, and that's the Triple Town versus Yeti Town case that we're going to talk about. Okay. Does anybody remember the Odyssey? You guys too young? The Odyssey was a competitor of Atari, and this game on the left here was called Casey Munchkin, and this is obviously Pac-Man. You guys all know Pac-Man, right? Still a good game. Okay, so this is one of the older opinions. Casey Munchkin came out, and it was around the time that Atari was developing the home version of Pac-Man for its console. And Casey Munchkin actually came out and beat Atari to the punch, so Atari was pissed. And they brought a lawsuit, and they sought a preliminary injunction on the basis that it infringed their copyright, and the district court denied it. And then it went up to the 7th Circuit, and the 7th Circuit reversed. And the 7th Circuit held that although there were certain elements of the game that were not protected, for example, the use of a maze and the use of dots to gauge a player's performance, and the use of a scoring table, and the use of these wraparound tunnel exits, things like that, those were non-protectable elements of the game. The court did find that there was infringement because of the similarities that were not necessary to create in the shape of the gobbler, the way that he moved, the shape, the fact that when the gobbler dies, he falls back on himself in a starburst pattern, and the distinctive gobbling action, as the opinion said, and the appearance of the appearance of the ghosts, and the total concept and feel. The court talked about the total concept and feel of the game being too similar. So Atari won that one. And I actually had a client recently call me and show me a prototype for a game that looked more like this than this. And they said, "Can we?" And I said, "No! No, you may not, because this is what is going to happen to you." And I actually sent them this side by side, and I said, "Do we need to have a phone call about this?" And we did, and I said, you will get sued, so please don't distribute this game." And I think that was the end of that. Okay, Capcom versus MKR. Now, have you all read this opinion? Anyone? You must. You must. Okay. Okay. Now, does anybody know? Has anybody played this game? Has anybody played Dead Rising? Okay. Do you guys know what genre this game is considered a part of?
Survival horror?
Yes! 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 You did tell me that they were gamers. Okay, excellent. I did not know that until the weekend that I was preparing the complaint in this case. I went onto Wikipedia and what is the genre? I need to understand where, what are all the elements that are driving the choices that the developers made. And there is, in fact, a genre called survival horror, and it has to do with survivors battling some kind of force, and usually you're barricaded in some kind of a structure where there's supplies. So we see this a lot in the zombie genre, right? I mean, is anybody watching The Walking Dead on AMC? Great, great show. I'm fascinated with the whole zombie apocalypse genre, so this case was quite fun to work on for me. But what happened with this case is, as I mentioned, Capcom did approach the creators of Dawn of the Dead. This is the 1979 version of the Dawn of the Dead, about potentially licensing their IP for use in a game. And those talks nothing came out of that, and they went on and they created this game. And at the premiere of the game, one of the developers was wearing a Dawn of the Dead t-shirt. Not a great fact. And when the game came out, MKR, which held the rights in Dawn of the Dead, was very upset, and they threatened to sue. And this went on for a while, and then eventually Capcom decided that enough is enough. We have to have a declaration that we're not infringing because we want to make a sequel. And we're tired of MKR harassing our distributors. They had sent letters to Best Buy. They had sent a letter to Microsoft, because this is an Xbox version, and said, this game is infringing and you need to stop distributing it. And so we thought, that's enough, no more. We're going to file a declaratory judgment action and ask the court to declare that this is not infringing. And the court went through a very interesting analysis. In the Ninth Circuit, there's an extrinsic test for copyright infringement and an intrinsic test for copyright infringement. Have you guys talked about this in class at all?
No, we have not. Go for
Okay.
it.
So, at least in the Ninth Circuit, in order to get to the intrinsic test, which is a subjective test that's for the jury, you have to get past the intrinsic test, which is a process by which the court will go through and it will look at the work and it will filter out all of the non-protectable elements of the work and then compare the works. So the court went through a detailed analysis of looking at the plot and looking at the characters and looking at the theme and looking at the dialogue and the setting and the pace. And having gone through all of that, the court looked at the works and said the similarities, which involved the fact that there were survivors barricaded in a suburban bi-level shopping mall, rummaging through the mall to find objects that they could kill zombies with, a chainsaw or a golf club or whatever it was. The court said that this is all of these elements. Oh, and the use of the helicopter, because the survivors got to and from the mall by use of a helicopter on a helipad. All of these elements are driven by the high-level, unprotectable concept of survivors battling zombies in a shopping mall during a zombie apocalypse. And so the court held that that was that the game did not infringe, and it dismissed the case on a motion for summary judgment. And the interesting backstory about this case is that on the motion to dismiss, the court actually watched the movie and played the game. We delivered an Xbox and the game to the judge's chambers. And can you imagine being a clerk for that judge? Can you imagine? There's no way we weren't going to win that case, right? So the judge, I mean, it was clear during the oral argument and in his opinion that the judge had in fact played the game. So that was quite fascinating. And when the case was over, the court delivered the Xbox back to me, and I said, I'll keep it. So, didn't give it back to the client. I said, you don't need it. I'm just going to keep that. That was my first Xbox, and that's the one that I burned out. Okay. Does anybody remember a game called Scribe Euless that was on Facebook a number of years ago? Okay. So this game, this was, I want to say, 2008. I don't really remember off the top of my head. But as you can see, there are a lot of similarities. Sure. Okay. As you can see from the slide, there were a lot of similarities in the game board in terms of the layout, the number of tiles across and wide, and the colors and the scoring. And Hasbro didn't like this, so they sued them for both trademark infringement and copyright infringement. And they claimed a copyright in 5 things: the game rules, the game tiles, the Scrabble dictionary, the game board, and the actual gameplay. And I didn't spend a lot of time on the slide talking about what is protected in the video game and game space in copyright, but I will tell you that with the exception of the game board, they probably didn't have a claim. You pretty much can't get copyright protection in game rules unless you copy them literally verbatim. And gameplay, general gameplay, is generally not protected. But the game board, they probably did have a claim given how similar that they look. And it doesn't have to look like that, right? I mean, you could design a game like that didn't look like that. I can tell you that if I represented Scribe Euless and they came to me with that, I would say, no, 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 no. And I would try and come up with something that looked a lot less like that. And I certainly would not have advocated that they use the name Scribe Euless. But that one, that did result in a lawsuit, and after, I believe after the lawsuit was filed, but before it settled, Scribe Euless changed the name to Wordscraper, and they made some changes to the appearance of the board. And then the case settled, and I think they changed the name again to Euless. I think that's what it was. So that was another one. A lot of these, so it's very common for a lawsuit to get filed and then the parties to settle, as we see again and again and again. Okay. Zynga versus Vastu. Anybody familiar with this case? Okay, one of my partners represented Vastu in this case.
Good luck.
Yeah, okay, so Vastu, it was referred to as the Brazilian Zynga. There were 6 games that Zynga challenged that they said was virtual ripoffs of Zynga's games, and this is just one example. This was Cityville and Mega City. And what Zynga argued in their complaint was that Mega City had so studiously copied their games that they even copied the bugs in the games, like when roads didn't go all the way through. Oops, copied a little bit too much. So they challenged 5 other games as well. And Vastu hit back with a very, very powerful answer and counterclaim, similar to what we saw in the EA versus Zynga case. I mean, oh, the irony here, right? And when you know who the lawyers are that are involved, the irony is particularly rich. But what Vastu argued essentially is what I was alluding to earlier about you have to look at what the plaintiff owns. And I refer to this as the you don't own what you claim I stole defense. What they said is, Zynga, you didn't come up with this. You ripped it off from somebody else. Take Farmville, for example. That's a ripoff of Farmtown. So you can't sue us because you don't actually own this content. And TechCrunch referred to this defense as, I know you are, but what am I? So there was some litigation that went on and some parallel litigation that went on in Brazil at the same time, and eventually the case did settle. Oops. Okay. Does anybody know Nimblebit and the game Tiny Tower? So Nimblebit is a tiny little company. I think it was a 3-person company, and they came out with this game called, they came out with Tiny Tower, and then Zynga came along with Dream Heights. And as you can see, they look pretty similar. It's the concept of an office building where you can populate it with businesses and people and do business and things like that. And there are a lot of similarities in the way that the games look. Although I would certainly make a lot of arguments about this stuff not being original. Yes?
Is this the one where I seem to remember hearing the smaller game company was actually Zynga offered to buy them, and then they rejected the offer?
That happens a lot, and I think that this was one example of that. Yes, yes. Didn't Zynga also offer to buy the company that made Farmtown? Maybe.
I think so.
Yeah. So Nimblebit didn't sue. Instead, they did what I like to think of as a shame on you letter. They posted an open letter. Zynga, we noticed you are about to launch a new iPhone game called Dream Heights. Congratulations. We wanted to thank all you guys for being such big fans of our iPhone game of the year, Tiny Tower. Good luck with your game. We are looking forward to inspiring you with our future games. So, yeah, they decided not to sue, but I think that sent a pretty powerful message. Okay, this is the Tetris case. Tetris is very aggressive in protecting its copyright and its trademark. And so I often tell clients, and I say when I give these talks, whatever you do, do not copy Tetris, because you will get into trouble. Well, Zio Interactive did copy Tetris, and it admitted that it copied Tetris. Its game was called Mino, for Tetramino. And it admitted in the case that it had intentionally set out to create a version of Tetris for the iOS. And it said, but what I did wasn't copyright infringement because I studiously copied only the functional elements of the game, the parts of the game that were driven by the rules. And the court looked at this and said, yeah, I don't think so. You went well beyond what you needed to do. While the court acknowledged, no, there are not copyrights in certain functional elements of the game, parts of the game that are driven by the genre, you copied things that you didn't need to in terms of, I mean, look at this. This was actually a diagram that was in the court's opinion. Right down to the number of squares and the color of the blocks, the size and shape of the blocks, the way that they fall, the use of ghost pieces and garbage lines and all of that stuff. And so the court granted summary judgment for Tetris on this case. And it's one of the few cases, one of the few recent cases where parties have actually gone the distance and gotten a ruling on the merits. So and it doesn't surprise me that Tetris would be the one to do it. So I recommend that you take a look at that.
But the genre, Jennifer, seems so narrow. You know, there are only so many ways of having falling block games.
Yes.
You have a game like Bejeweled, which is sort of, I mean, align the colors, align the blocks, disappear in rows, which is not, I don't know if Tetris has ever sued them, I would think not.
I don't think so. I don't think so. There are a lot of different kinds of games in this genre. NG Moko makes a couple of games. Topple, you heard of Topple? Topple 1, Topple 2, Topple 3. I've been involved in some disputes relating to those games. There are a lot of different ways to have a block stacking game. But this goes way too far. And this is actually another example of a case where the court found that because this was a game that was fanciful and not based on real life, that there was greater protection for it, much like in the Pac-Man case. You can't equate this to something that you see in real life. So you don't have to have a game that looks just like this.
Well, it kind of looks like my desk.
Well, that's, I don't know, that looks quite organized, actually.
So what part of the Tetris game did Mino say was protectable by copyright? If they're saying that what they've done there is
Yeah, I
not
really don't think that they
copyright
admitted that there was anything that was protected by copyright. Yeah, it was a pretty crazy,
infringement?
pretty crazy argument. Yes, I did copy. Very carefully.
Yeah.
Yeah. Okay. I think you all know about the EA versus Zynga case. Have you talked about it in class?
Yeah, we've alluded to it.
Okay. I won't spend too much time on this case. It was fascinating when EA sued Zynga. A lot of people in the industry were very surprised that they did this and were concerned about what would happen if a court actually ruled on it. And you know, EA argued that their complaint was very accusatory and just condemned Zynga for their whole business model and copying everybody else, and you know, gave a laundry list of all the things that Zynga had copied. And not surprisingly, when Zynga answered, it moved to strike those allegations and said they're not pertinent to the issues at hand. And by the way, you didn't create the life simulation genre, Activision did. And you weren't the first ones to bring the life simulation genre to Facebook. We were. We had Yeovil, we had Cityville, and all the things that you see that you're complaining that are the same in our game as in your game are actually elements that we pulled from our prior games. And that's actually, I think, a pretty compelling argument, because you really can, in this kind of genre, in the real life simulation genre, you really can argue that everything that is a similarity is something that needs to be there. Because if you're going to have a game where you have a starter home and then you build the home, you have to have choices for what paints you're going to put on the wall. And there's a limited range of choices. And of course, one of the similarities that they had pointed out was that, well, the characters have bodily needs that must be attended to. That's present in both games. Well, yes, we all shower, we all eat, we all sleep, we all do that. That's not something that probably most of us would think is something that's protected by copyright. So we're never going to get to find out what the court would have done, because the case settled very recently. In fact, it was just last month, without any substantive ruling by the court. Hold on one second, my tissue again.
In a case like that, aside from the very particular way in which you implement the simulation, is there any way to argue more broadly that there is copyright infringement? Because really, what's original? You're taking it all from life. Everything is copied from life.
Mm-hmm.
So unless I'm drawing the stove a different way, or just conceptually, I have a harder time seeing how you succeed in a copyright complaint.
I think it would be difficult, particularly in a game where what you end up with is based on decisions that the player makes.
Yeah.
I mean, you know, when whoever created this for the complaint spent some time creating these two works. This isn't a kitchen that is just shows up in the game. You place the objects and you paint the walls and you create a character that looks like this and is wearing that. Now, if I were representing EA, I would argue, well, why did you give the choice of the exact same striped shirt and the boots and the hair and all that kind of stuff? I would argue that. But you know, I don't honestly know where a court would come out on that. And I don't know if I want to know. Do you?
Well, if I'm not litigating it, sure.
Really? Well, but also as a gamer, I mean, do you? You know, I don't know. I'm a litigator, and I'm more often on the defense side, but I'm on the plaintiff side too sometimes. And so I just don't know. I don't know. I'd be concerned that a court would draw the line in a place that it shouldn't draw the line, and it wouldn't be good for innovation. I mean, I'm on the side of technology usually, and so the Sony versus Universal, and so I do have a bias about fostering innovation and fostering more content.
And every time you restrict access to an element of storytelling, you affect the stories that people can tell. And you know, that seems a bit high level, but if you ever try and write a script or a game scenario, you'll see that's really real. Yes, you can make a kitchen cabinet, but you can't make it that way. Well, that has a chilling effect on creativity, whether you like it or not. And ignoring that is just not realistic.
Right. Right. And back to that quote that you mentioned earlier about copyright being a monopoly, that kind of got me thinking. I mean, yes and no. It's a limited monopoly because copyright protection only protects expression and not ideas. And also, unlike patent, independent creation is a defense. And so if you came up with a kitchen cabinet that did look just like that, and that was something that was protected by copyright, that's not necessarily a problem if you didn't copy it. So the last case that I want to talk about in the copyright context is Scribe versus Lolabs. This was a case from this fall, and this is Triple Town, and this is Yeti Town, and it's a match 3 game where you place 3 objects together, and then they become the next object up in the hierarchy, and then you try and I'm not sure what the highest level is, but put 3 bunches of grass together and then get a bush. Put 3 bushes together and get a tree. Put 3 trees together and get a cabin. Sorry. And then, so like I said, these companies were working together, and what happened was, the backstory here is actually quite interesting, particularly from a litigator's perspective. When we take discovery, find out what really happened. The companies were working together, and things went south, and one of the executives from this company sent an email to one of the executives for Scribe and said, gee, I hate to be the bearer of bad news, but we're coming out with a game, a match 3 game, and you're not going to like it. And no, in fact, they did not like it, because it looked a lot like their game, and the icons looked the same. And Triple Town, Yeti Town, and it was this exact same concept. The only difference was that it was a snow field instead of a grass field, but the object hierarchy was the same. And you have the Yeti is the protagonist that's trying to interfere with your progress, versus in Triple Town it was a bear. And so Scribe sued Lolabs in the Western District of Washington, and the court, and then Lolabs moved to dismiss, and the court denied the motion to dismiss and said that, based on the pleadings at least, that there were enough similarities there that they thought that they had stated a claim, and the similarities included the overall look and appearance and the similarities in the object hierarchy. And the case settled not too long after the motion to dismiss, not surprisingly. And as I understand it, although the terms of the settlement are not public, as I understand it, Yeti Town gave the IP in the game to Triple Town. So both games are still out there as far as I know, and according to my son, Yeti Town's a good game, so give it a try. Okay, so let's move on to talking about Trademark. And we will try and breeze through this pretty quickly because I know that we've not got that much time left. Okay, so unlike copyright, trademark is governed by both federal and common law. And what it protects is the use of a trade name or trade dress in commerce to identify a single source of goods or services. And the claims that usually arise in this space relate to the use of a trademark or name in a title, or sometimes within the app or the game itself. I think, John, you were mentioning that earlier. Sometimes you see examples of a trademark being used, the name of business being used within a game. And I have this bullet point here about I'm starting to see some disputes relating to use of the keywords in the App Store, and I say gripes in parentheses because I haven't actually seen anybody file a lawsuit over this, and I haven't actually seen anybody send or receive a demand letter on this topic, although I'm sure some have been sent. What I've heard from my clients is on both sides of the equation. I'm being accused of using keywords to drive traffic to my game, and I'm incorporating somebody else's trademark in my keywords. And again, like I said, clients sometimes lose sight of, where they started, because I've had the same client who was accused of using somebody else's keyword, and I recommended that they change it actually because there was no reason to do it other than to drive traffic. Then complain about how other people are using their keywords in the name. And it's particularly interesting when clients choose a name for their game that is purely descriptive of the game. and then complain about somebody using those words, and that does describe the game itself. So it's not exactly a very robust claim. Okay, so for trademark infringement, the elements of a claim is that you use another's mark or name in commerce in a way that causes likelihood of confusion as to the source, sponsorship, or association between the plaintiff's mark and the good at issue. The defenses that typically arise are classic fair use, which is when you use the mark, but you're actually not using it in a trademark sense. Nominative fair use, when you are using the mark, but you're actually referring to the plaintiff itself. Parody and First Amendment. First Amendment is the one that is that I see a lot, and that comes up in the cases that I'm going to talk about. And that is when you use the mark, but the use of the mark has artistic relevance to the work, and it's used in a way that is not explicitly misleading. Let me give you an example of First Amendment in a trademark context, beyond the cases that we'll talk about. A few years ago, I represented a company it was a museum called the Burlingame Museum of Pez Memorabilia, and it was a small shop that was run by a guy that just loved Pez. He dedicated his life to collecting Pez memorabilia. Why wouldn't you? I don't know why you wouldn't. You know what? There are Pez conventions. There are die-hard Pez fans. And so he just operated the shop. It hardly made any money. I don't even know if it was enough to pay his rent on the shop, but he just loved Pez. And he built an 8-foot-tall, giant Pez dispenser. We referred to it as the snowman because it was a snowman-themed sculpture. And it actually did dispense packages of Pez. And it had a big disclaimer on it that said, not affiliated with or created by the Pez company. The Pez company sued Gary, his store, and we brought a motion arguing that he asked for the snowman to be destroyed. Can you believe it?
Heart-wrenching.
Pez wanted the snowman destroyed, and we argued that it was not trademark infringement because it was protected by the First Amendment. It was an homage. It was the use of the appearance of the snowman had artistic relevance to the message that Gary was trying to send.
Did you argue parody as well?
Yes.
Okay.
Yes.
What's the message he's trying to send with the giant Pez dispensing snowman?
He's expressing his love for Pez.
Point taken.
Yes. We argued nobody was likely to be misled into thinking that it was created by the Pez company. Well, the court never ruled on that motion because the case settled shortly thereafter. I mean, can you imagine the PR hit from that?
Why would they sue their biggest fan?
It's happened before in other genres. It never makes any sense.
Yes. Yes.
Weird. Yeah.
So the snowman lives on.
It was crossed at the 6-foot-tall snowman Pez dispenser.
Okay, so let me just run through the cases that I have for you. We've already talked about the Hasbro versus RJ Software's case, and I don't have a slide for you on that. That's the Scribe Euless case. Blingville versus Zynga. Okay, so Zynga has a lot of games that end in Ville, and they took the position that they own trademark rights in the Ville. And I think actually, if I click on this, more of them will pop up. No?
Yeah, it should.
I think the taskbar is active, so it's like overriding the clicker command.
Oh, rats. I messed up. Help me.
I think it should work now.
All the other Villes are supposed to pop up when, see? Okay,
I'm
there they
doing
are.
it.
Yeah. Frontierville, Cityville, Farmville, Petville, Fishville, and Yeoville. And so Blingville developed this game, and they got a cease and desist letter from Zynga that said, hey, stop using Ville in your name or we're going to sue you. And so Blingville actually sued them for a declaratory judgment that it wasn't infringing, and then they rolled over pretty soon after the complaint was filed, and they actually entered into a consent judgment acknowledging that Zynga had rights in the name, and so there's no more Blingville, unfortunately. But this was an example of use of a trademark in the name of a game. And then this is another example, the Learning Company versus Zynga. This comes up a lot. The Learning Company had a game called the Oregon Trail, and then Zynga developed a version of its Frontierville game that they called the Oregon Trail, which both involved a family heading west in a wagon and all the various things that they encountered along the way. And one of the things that I found fascinating about this is that one of the things that the players had to deal with was that they frequently have dysentery. Part of the complaint. I'm not kidding. So.
That was in both games?
Yes. Yes. Interesting choices, right? Yeah. So, but you know what? You know what I would argue? What would I argue? It was very common. It was very common in that area. We all had dysentery. Of course you're going to have dysentery in the game. It's like a helicopter. It's got to be in the game. Wouldn't be realistic if you didn't have it. So the backstory here is that Zynga had approached the Learning Company about developing a version of its game for Facebook. Talks fell through. Zynga went ahead and came out with that game. The Learning Company moved for a preliminary injunction, and then Zynga changed the name. So Zynga rolled over on that one. Okay. I think you guys have talked about Grand Theft Auto San Andreas in this class.
Yeah, and we will next class.
Okay, okay. So Grand Theft Auto is set in East Los Santos, which is a parody of East Los Angeles. And there is a gentleman's club in East Los Angeles called the Playpen, the Playpen Gentleman's Club. And in this game, there is a gentleman's club called the Pigpen. And so EA was sued, and they argued that they asserted the First Amendment defense. So this was, let me back up a step. This is an example of the use of a trademark within the game itself rather than in the title. And so you'd have to go along and you'd have to play the game and you'd have to, get to the Playpen to know that it's there. It's not featured on the packaging or in the title of the game or anything like that. And so the Ninth Circuit looked at this and they agreed that yes, this was protected by the First Amendment. It has artistic relevance to the game because you're trying to create a parody of Los Angeles and you're going to feature elements of East Los Angeles that are actually real. And it's kind of a funny twist on the name. And they said nobody is likely to be confused about thinking that the owners of the Playpen actually endorsed the game or created the game. And they said it doesn't matter if a player could spend all of their time within the game at the Pigpen, because that wasn't the draw to the game. Some may disagree. I actually haven't played this game, but if you do, visit the Pigpen. See what it's all about. Okay, right of publicity. As you know from what John has said, this is not a creature of statute. This is a creature of the common law. It is the right of publicity is a right. It's a personal claim arising out of privacy law. The laws vary state to state, but some you don't have to be famous. You don't have to be alive. Some states have postmortem statutes. There's a lot of overlap between trademark and right of publicity claims. Oftentimes, when somebody has a right of publicity claim, they also assert a trademark claim. And the First Amendment comes up a lot in this context too. Okay, so just very quickly, the cases that I wanted to show you are pretty amusing. The first one is the Justin Bieber case. There's a game that came out called Joustin' Beaver. Yeah. And so the beaver is going down the river and he's navigating the whirlpool of success and he's being chased by photogs who are trying to take his picture and they're seeking autographs. And Justin Bieber's camp.
When does he joust? When does the jousting occur?
Oh, he's got a little thing.
So
oh yeah, he's trying. Yeah,
okay.
that's how he's getting. That's how he's getting the fighting the
photogs. A horse sometime in the middle of the game.
Oh, it's actually, I have it on my iPad. It's a pretty fun game. And then if they catch you, if they take your picture, a thing pops up that it looks like the TMZ gossip website, and it's got the picture of the beaver. It's pretty funny. But they got the developers of the game, RC3, got a demand letter from Justin Bieber's camp, and then they actually filed a declaratory judgment action in Florida, and Beebs got it dismissed on personal jurisdiction grounds, and they didn't refile. So there's no opinion on this, but it was an example of a celebrity who didn't like that his likeness was used in this. And I think, I mean, you could argue it both ways, but I mean, clearly look at the beaver's hair, right? I mean, it's obviously Beebs. So I thought that was a rather amusing case. Then we have the John Dillinger case. This was, EA has a series of games called The Godfather, and within this game, one of the weapons that the player can use is a John Dillinger Tommy gun. And John Dillinger was an infamous gangster from the 30s, and his heirs sued for right of publicity and trademark infringement, and lost on the right of publicity on the basis that the Indiana didn't, the post-mortem statute was not retroactive because he had died so many decades before the statute went into effect that granted rights, post-mortem rights for celebrities. So anyway, this was another example of the use of a trademark within the game itself. Okay, Kirby versus Sega. This game on okay, so do you guys remember the band Delight saying Grooves in the Heart? Grooves in the Heart? Okay, this is Lady Miss Cure, and Sega came out with a game called Space Channel 5, and the character's name was Ooh La La. And Lady Miss Cure often would say Ooh La La. And so they had actually approached Lady Miss Cure about doing an endorsement for the game, and she declined. This happens a lot, okay? And she said, you know, that they appropriated her likeness, and things that she pointed to were, you know, the short skirt and the boots and the ponytail, which, you know, in my view is just a standard Saturday night, right? It's not nothing creative about that. And she lost. The court found that there were enough differences in the way that the character moved. It was a game. In this game, you replicate her dance moves. They said she danced differently, and her appearance was sufficiently different that the use was transformative, and it was protected by the First Amendment. Okay, one last slide. Okay, you guys, this case settled relatively recently. Do you guys know this case? No Doubt had entered into, there was actually a contract in this case between the parties. No Doubt had entered into an agreement with Activision to have they did motion capture, and they had avatars in the game, and you were supposed to be able to use the avatars only to perform No Doubt games. But the game, you could unlock the avatars and use them to play other songs other than No Doubt, and you could also manipulate their voices so that you could make Gwen Stefani have a man's voice and have male members of the band have her voice, and they didn't like this. They said that this went beyond the scope of the consent in their agreement, and this case got litigated for a number of years, and it only recently settled, I think in October. So I think we're out of time, so I'm not gonna be able to move into the practical component, but hopefully you enjoyed the discussion of the games, which I think is the most interesting part of this area of the law.
Just going to add two quick footnotes before thanking Jennifer. You will find on the blog now that the materials are accessible to you through the blog, and there are two cases, Incredible Technologies versus Virtual Technologies, which is about a golf game that's well worth looking at in this context, and then Pleadings in Electronic Arts versus Textron, which is about using helicopter games and helicopter names and kind of real-world weaponry names in a game that are at least complementary to the subject for today. I think you have had a real privilege, and we all have, in having Jennifer come up from San Francisco, especially to be with you. She's tacking on a Whistler trip at the end of this, but the real reason she's here is to teach you guys, and she did a magnificent job, so let's thank her. And thanks for all